to our program tonight. The volunteers who comprise the Coalition's board believe that democracy works best when individuals have the information they need in order to hold their governments accountable. And part of our mission related to that principle is to promote discussion of and knowledge about access to that information. Your presence here tonight helps us further that mission, and for that we thank you very much. Because so many of you have been actively engaged in the in a public quest for information, we've structured this program tonight rather than have a big lineup of speakers. We want to allow ample time for conversation and Q&A. And so you'll have plenty of time to ask questions once our talk for the evening is over. Several members of the MNCOGI board are here to join in that conversation. And these are people who've had considerable experience working with gaining access to public information. So first though, I'm going to introduce our moderator. Whether or not you recognize him, you probably have seen Steve Brandt over the years, either running or cycling on some Minnesota road. Steve has pretty much covered the state, either on foot or pedaling his bike. He always had a formidable determination when he's doing that. It's the same impressive approach that Steve brought to covering schools and many other beats for the Star Tribune over the years. Steve retired from that job recently, and the newspaper's loss is our gain because now he has time to join us for this program tonight. So Steve, I'm so pleased to turn the program over to you.
Thank you, Sharon, and welcome everybody. As Sharon said, I'm a recovering reporter, and the first thing I need to do tonight is to let people know that Aaron Bai over here in the orange shirt will be recording tonight's program so it can be available to people who couldn't be here tonight. His plan is to put it on YouTube, and then there will be a link from the MNCOGI website. That's the Minnesota Council on Government Information, and that's www.mincogi.org. And so you can feel free to tell your friends who couldn't make it here tonight about that. I'm not the expert here. I'm here to keep the program moving along, and the fellow who's the expert is sitting next to me. His name is Don Gemberling, about whom you'll hear more shortly. And we have several other people who are much better versed in the audience. They're MNCOGI board members in the Minnesota Government Data Practices Act. I think if there's one thing I'd like to say tonight, it's that the Act is not something just for reporters or lawyers. It's something that is a tool for everyday citizens. We hope to cover things like what the law says and doesn't say, how you can get interpretations on fine points in the law, where to go, tips on writing a request under the law. I'm hoping that you'll come out of here better informed. The fellow I'm going to introduce, Don Gemberling, is somebody I've known since the late 70s, when I was a cub reporter instead of a 40-year veteran. He began working professionally on the issue of transparency, government accountability, data privacy, and the implications of technology on people in 1973. And for more than 30 years, he led the Minnesota Department of Administration's efforts to shape the Minnesota Government Data Practices Act and to help government agencies comply with the Act. He also helps people like you exercise your rights under the Act. He's a board member for MNCOGI, the Minnesota Council on Government Information, Coalition on Government Information, excuse me. And he's often serves as MNCOGI's official spokesman, so you may see him quoted in the press and on the air. He testifies before the legislature on issues related to government transparency, accountability. He graduated from McAllister Law School, or McAllister College and William Mitchell College of Law. So, Don, it's all yours.
Thanks, Steve. Okay. higher chairs when you get older are nice. So, okay. Thank you again, Steve. I'm going to lead you through some of the Minnesota Government Data Practices Act, okay? I can't lead you through all of it because we would be here for a very, very long time, okay? So I'm going to hit what I think are the high points for folks like you who have an interest in education and anybody else who might have an interest in something else. As far as I'm concerned, at any time you have a question, just ask, and we built in time for the questions and discussion at the end. Okay? Now, what I encourage you to do, you're already making me a little worried, is don't be a stereotypical Minnesota audience. And that's shy and too self-conscious to ask a question. So how do I know you're a stereotypical audience? There's only one person sitting in the front row. Okay, so church seating is full back there. So, as Steve said, I've been doing this for a long time. And part of the reason why I do it is I keep learning. I came out of an academic background in which learning was really encouraged. And one of the really sad things I've learned recently is that one of the problems with how we deal with access to government information in Minnesota and how we also deal with issues of data privacy when information is held by the government is that too many people just don't know what their rights are, okay? You know, I still get calls from people who say, hi, I'm a parent in a school district. Can I go down to the school and look at my kids' records? And I say, oh yeah, absolutely. As a matter of fact, there are 2 laws that guarantee that right to you. And then I also say to them, but don't ask to see your kids' records, because you have to be careful how you ask things in our statutes. Because sometimes you'll get what they're willing to give you based on what you ask. And we'll talk about that kind of thing too. So, now, the materials for tonight are intended to give us some kind of outline as to what we're going to talk about. But they're also intended for you to take away, okay? And to have reference. And if you haven't gotten any materials, they were over here, and Sharon will bring more, okay? So, one of the things I've been doing for years is I actually collect cartoons about government transparency and issues of privacy. And this one is always my favorite. And I have to tell you, I altered it from the original, okay? Because it illustrates what I was talking about earlier. I'm going to talk to some judges next month about the Data Practices Act, which is really going to be a challenge because I know about half of them hate it. So that's interesting. So now that's the front cover, as it were. And the next piece, and we'll come back to these, by the way, is a handout that tells you what your rights are to access government data in Minnesota, okay? And the way this particular handout is laid out is on the left side it tells you what your rights are. And on the right side it tells you what kind of a parallel government responsibility is so that you can actually make your rights mean something, okay? Now, the next piece is when you're going to kind of look at it and say, continuum of data and information, what could that be? Well, things like government data and summary data are defined terms in our statute. And then we get into things about, for example, what about the status of information that you can get out of an electronic database? Or what's the status of information you can get out of government files in general? And we'll go over this piece, but what I'm leading you to there is one of the realities of our statute is that it works on data that exists, okay? And so if you go in and ask a government agency, for example, I'd like a list of all of the people who work in the governor's office in the state of Minnesota. And the governor's office responds with, well, we'll get you that in a couple of weeks. And you wonder, why is it going to take them a couple of weeks? And at the end of that couple of weeks, they provide the list, and they say, oh, by the way, It cost us $500 to generate that list, and before we hand it to you, you have to pay the 500 bucks, okay? Now, that's actually a real controversy that happened a number of years ago. And the problem is that list did not exist in the form in which it was being asked for. So somebody in the governor's office who was trying to keep somebody happy went to work to generate the list. And then somebody else in the governor's office who counted beans said, oh, you spent a lot of money doing that, we should be able to get that back. So you have to be careful about how you ask for information. And we'll talk about some of the tricks with that. So the next thing is, this is one of my favorite old charts. One of the things that makes our Data Practices Act different than any other statute like this in the entire known world is that it uses a very detailed data classification system. And what this piece shows you is how that data classification system plays out. And what it is a series of definitions. And so this particular piece starts at the highest level of how government information can exist, and that's government data. And government data is defined in the Data Practices Act. We'll talk about that. And then at the next level down, our statute basically says that there are three kinds of data that the government holds. One is data about people, and that's the vast majority of data that the government holds. Then there's also data not about people, which is pretty much everything else. And then in weird circumstances, the government also keeps data about people who are dead, okay? Again, so much of our Data Practices Act is a history of controversies. And so then below that level, you get the actual classifications of data. And what's important about the classifications is how they affect access. So if you look on the left side of the chart, you'll see if there is public data on individuals, and there's lots of that. Then what that means in simple terms is any member of the public can get access to it, period. As a matter of fact, it's the government's obligation to make it available to the public. However, if the government has private data, that's data that's about people, that's not public, but is accessible to the person the data is about. In the case of schools, the biggest chunk of private data is data about students, okay? And I want to emphasize, data about students is not all, but mostly private, which means parents get access to it, okay? When a kid gets to be 18, the law changes, and then parents don't get access anymore unless their kid is a dependent, as defined in the Internal Revenue Code. And if you want me to explain that, I'll explain it, but basically it's a function of how federal law works. So, but the emphasis here is when a school district maintains data about your children, you have access to that data, okay? Lastly, there's a classification called confidential, and that's the most restrictive classification. If a government agency has confidential data, it's not public and it's not accessible to anybody except government entities authorized to get access to it, okay? What's a kind of confidential data? The most common type in the world, or in the world of Minnesota government, is law enforcement data, okay? When law enforcement collects data to investigate crimes, that kind of information is confidential. There's some exceptions to that. In school districts, there's not very much confidential data. If a school district, for example, may be engaged in litigation, the data associated with that litigation may be confidential, but in school districts there's not much stuff that's confidential. Okay? So, now, next piece. Our statute started out at the beginning when Steve and I were both a lot younger. Not as a Data Practices Act, not as a Freedom of Information Act, but it started out as what was called in those days the Data Privacy Act. And if I tell you this happened in 1974, that helps explain why that was the emphasis. Because in the early 1970s, and actually earlier, we began to understand that information was having a greater effect on people's lives, mostly because more and more information was being collected, and more information was being collected because it could be processed using computers, okay? I actually started working at the state of Minnesota doing criminal justice information systems. So people came to realize in that time frame that even though information was having a greater effect on people's lives, there was a little or no law that dealt with that reality. Okay? Now let me give you an example. And now I always kind of got to look to see how old people are. Okay? Yeah, most of you are younger. If you were employed in 1973, in either the private sector or the public sector, and you had some concerns about what might be in your personnel file, and you went to your employer and said, I want to see what's in my personnel file. Now keep in mind, this is 1973. How many of you think you would get access to what was in your personnel file? Ah, good. None of you would, unless you had an employer who was willing to give you access. Okay? If you went to a lawyer and said, hey, I'm having this fight with my employer about access to my personnel data, what can you do to help me? If it was a good lawyer, he'd say, not a heck of a lot. He or she would say, not a heck of a lot, because there were no laws guiding that kind of issue. Could you come up with some real creative legal theory to deal with it? Yeah, sure. But as people in this room know, creative legal theories are very expensive. Okay? So, part of the emphasis in the data privacy movement was, number one, to make sure that people got access to information about themselves. And then there was also emphasis on things like what happens to information that's collected from us, and should we be able to exercise some control over that. And so what happened with our Data Privacy Act was the legislature established rights for subjects of data. Okay? And that was really the foundation on which our statute began. Okay? And so this next handout lays out what your rights are. They include things like the right of access, the right to be given notice when data is collected from you, and the right to challenge, interestingly enough, accuracy and completeness of data. Now I want to emphasize this is only when data is held in the government. There are entirely different rules for the private sector. Okay, so now, lastly, and I think there's some mention of this, part of how you gain access to data in Minnesota, public data, in practical terms is you have to make a request. Okay? Now the statute doesn't specify how you make a request, it just says you have to make a request. Sometimes government entities will say, if you want to get data from us, you got to fill out this form. Okay? There's nothing in the statute says they can't do that, and if that's what they say, with limited exceptions, that's what you should do. Okay? Because that's the easiest and most expeditious way to get access to data. So, but what we did in this sample letter is essentially give you a fill-in-the-blanks thing if you're dealing with a situation in which you're not sure how to get access to government data in a given government entity. And that's what this sample letter is about. Okay, now let's go back. After the initial push to have a, quote, data privacy law, then there was a long discussion, and by long I mean like 4 years, 5 years, about the fact that in the 1970s, Minnesota had an ancient public records law. And it was ancient both in age, and it was ancient in how it worked, and it was ancient in its subject matter, okay? And so a number of people, and primarily the media community in Minnesota, went to the legislature and said, okay, fine, you're doing this privacy stuff, but we need a better law on public access to government information. So there was a fairly long negotiation, and that negotiation culminated in 1979 in the passage of language that got added to Minnesota statutes to establish, with pretty much no questions, what the public's right is to get access to government information in Minnesota. Okay? Now, some highlights of what that is. The definition of the subject matter of the Data Privacy Act, and that's what it's called, it has been called since 1979, is government data. And if you look at that definition, what you'll see is that government data is all data. Now keep in mind, we're talking about data, we're not talking about records, because that's a different issue. It's all data that's collected, received, created, used, maintained, or disseminated by any government agency in Minnesota. And that includes state agencies, counties, cities, school districts, all the miscellaneous kind of things like watershed districts. My favorite has always been the weed control districts. I once gave a presentation to the 127 people who do weed control in greater Minnesota. So, and they're subject to the Data Privacy Act. Okay? So, the definition goes on to say that data in a government agency is government data, no matter how it's maintained, no matter how it's used, no matter what physical form it's in, it's all government data. Okay? Now, that's a pretty powerful tool to have, because one of the things that happened with our old public records law is a couple of cases in which our Minnesota Supreme Court said a given piece of information was not a record. Okay? It was not an official record, it was the actual language. And so part of the reason for the definition of government data is to get away from that kind of parsing. And so one of the things that I still get aggravated about is I go to presentations by government lawyers, and they'll say, well, you know, one of the problems with the Data Privacy Act, it was enacted in the late 70s and it doesn't deal with computers. Okay? Well, I take you back to the definition of government data. It's all data collected, maintained, received, disseminated, or created by any government agency, no matter what physical form it's in. Okay? Now, to me, that covers data on computers. Okay? And I see why government lawyers sometimes argue against that, but that's another issue. So our statute is very clear, and if you looked at the outline of the data classification system, underneath the definition of government data, you'll see the words, you see the word everything, okay? Because that's how it's been interpreted, okay? So at the get-go, when you go into a government agency, you're presumed, and this is stated in the statute, you're presumed to have the right to get access to any public data that's held in that agency, okay? Now, how does that work operationally? Well, if you look at your rights, on your right to access to government data, at the very first one of the issues and it's getting to be more of an issue these days, is at some point the legislature said, part of what happens elsewhere in the world is cost is used as a barrier to public access. Because somebody will come in and say, I want to get copies of this data, and the government agency says, well, we get to charge for copies of the data, and what they charge is pretty expensive, okay? One of my favorite legislators he used to represent Shoreview, was once quoted a price by the Department of Transportation to get access to data in the neighborhood of $18,000, okay? And Phil fought them in court and eventually got the data for not $18,000. So what the legislature decided, and this is kind of, I like to think of it as consistent with the way Minnesota thinks about things. They decided that if you're willing to come into a government agency and look at government data, you have a right to look at that data, and the statutory language is inspect at no charge, okay? Now, the upside is you don't get charged. The downside is you have to go to the government agency and look, okay? Now, the government agency's responsibility, if you look on the right side of the chart, is they're supposed to be maintaining that data in such a fashion as it's easily accessible for convenient use by the public, okay? And by the way, all of this language is statutory. It's not something made up, okay? So when people call us, they say, what's the quickest, easiest, cheapest way for me to get access to government data? Part of what we say to them are, are you willing to go into the government agency? And if they say yes, then we say, call them up, see what their policies and procedures are, and ask to inspect the data, okay? Because that's cheap. Now, when you do that, and this is something else we recommend, let's say, for example, you're interested in a topic like, let me think of something non-controversial. What was the process that a school district went through to decide to close some schools? You have a right to access to that data, okay? And if the school district says, well, we'll deal with that in discussion. That's a reasonable request for access to data under the Data Privacy Act. Now, the practical problem is it's going to take them a while to honor your request. But from your standpoint, again, your greatest ally is asking to inspect that data. Because once you see the data, some of it's going to be wheat, some of it's going to be chaff. You can say, wait a minute, I'd like copies of pages 1, 14, 27, 8004, whatever, okay? And then the Data Privacy Act says you have a right to get copies, and you can only be charged the reasonable cost of their providing the copies, okay? And that includes searching out and retrieving the data, but that's another reason why you should inspect it in the first place. Now, the legislature a few years ago, after some complaints, added to the statute of limitations on paper copies, and that limitation is if you ask for less than 100 pages, a government agency can't charge you more than a quarter a page, okay? I was at whatever Kinko's it's called these days yesterday to copy some stuff, and I think I got charged 13 or 14 cents a page, so a quarter isn't bad, okay? So, now, when they're deciding to charge you, if you look on the right side of the chart, you'll see that they can only charge you the actual reasonable cost of providing the data. But let me give you an example of, keep in mind, when I worked for the state of Minnesota, what I did oftentimes was to talk to citizens like you, calling to complain about something a government agency was doing. I also spent a lot of time talking to government agencies complaining about people like you. So I never knew which one was more fun. But we got a request for an opinion. We'll talk about that in a minute. From a guy who had gone to a police department. And he wanted information about 2 or 3 things that had happened in the community. And he asked for copies. He was willing to pay for the copies. And I think he got, my numbers are a little hazy because it's been a while, but he got like 40 pages, okay? And that was before the quarter limitation was in effect. And I think if I remember right, he got charged, it's either $400 or $800 for 40 pages. Now, even in a worst case scenario, that's outrageously too much money. So he asked them to justify what the charge was. And they said, well, you know, in our agency, the deputy chief of police has to copy things. Second most expensive person in the department, okay? And then when he copies things, the chief has to look at them and make sure they're copied right. So he was charged the salaries of the 2 highest paid people in the police department as part of the copying cost, okay? Now, in the system that we use, when he asked for an opinion from the Commissioner of Administration, the opinion from the Commissioner of Administration said, using the statutory language, that's not actual and reasonable cost of making copies, okay? So, I think he actually got most of his money back. So, now I skipped one thing. One of the limitations in our statute is when you ask for data, either to get inspected or to copy it, there's no time specified in our statute for access to public data, okay? There's nothing that says it has to be provided within 10 days, 2 weeks, whatever the case may be. It's one of the problems with the statute. When government agencies do what they're supposed to do, it's not a problem, okay? Because if they respond within a reasonable time, that's what the real standard is whether or not the response, whether or not the request was responded to in a reasonable time. And the reason that's the default when the legislature doesn't specify something, the default was the agency's conduct reasonable? So, and again, the Commissioner of Administration with this authority to issue opinions, which I keep alluding to, you know, things like never getting an answer is not an appropriate response, okay? Saying that to provide 2 pages of, for example, a budget 2 pages out of a budget should not take 2.5 months, okay? Because that's clearly not reasonable. So now, one of the things about our statute that doesn't get used a lot, but when you look at government data, sometimes It's the functional equivalent. What am I reading? Okay? Because I don't know what Title 27D12 of the 1993 Congressional Budget for Human Services blah blah is, okay? So our statute actually says if you look at some government data and you can't understand what it's saying, you have the right to be informed of its meaning, okay? That's not a thing that comes up very often, but it's important to know. We talked about the no more than 25 cents for 100 copies. Now, let's say that the government agency says to you, you can't have this data because it's not public, okay? What the statute says is if they do that, you can say to them, okay, I want you to put in writing that you turn me down, and in that written response, I want you to cite the statute or federal law that allows you to treat this data as not public, okay? That's the very last bullet on the left side. Now, in disputes, you really always want to do that because it does two things for you. Number one, the first thing it does is the government agency, and keep in mind I was a bureaucrat for almost 40 years. The government agency says, oh my God, I've got to put in writing that I'm saying no to this person. And you'd be surprised how many times they change their mind, okay? The second thing it does is when you get that written citation, it gives you the chance to go and look to see if whether or not under Minnesota statutes or federal law, the data is really classified in the fashion that they say it's classified. So for example, if someone were to say to you, well, I can't give you the salary of the superintendent of schools because that's private data, and they cite Minnesota statute section 13.43, if you go look at section 13.43, not only does it not say that, it also says the salaries of all public employees are public, okay? So that's the second advantage with getting a citation. Okay, so now questions on public access before we go further. Go ahead.
Is a school district's bank account statements public?
If I remember right, yeah, except to the extent that they would reveal ways of you getting access to the actual bank account and being able to do something bad to it. The numbers ought to be public, okay? So,
Wonder if we could hold the questions until Don's done with his presentation. We've budgeted about an hour for questions, and I think Don will be winding up shortly.
okay. Right. Now I want you to go to your rights as the subject of government data. Okay. The further we go into the kind of society we're becoming, which is a huge society in which virtually everything we do is tracked by somebody some way or another with a different kind of technology, the more I happen to think this part of the Data Privacy Act is very important. Okay? Now, how many of you are parents? Okay. When parents with kids in school, I should have said that part. I'm a parent. No more kids in school. When you get questionnaires from the school district that ask you for information about your children, how many of you remember receiving a notice that tells you the things that are listed in the first paragraph on the page labeled "Your rights as the subject of government data"? Take a quick look at it. Okay. You looked at it. How many of you remember ever receiving anything like that? I got 2. I'm going for 3, 4. Okay. All right. Now, the purpose of that part of our Data Privacy Act, it's got multiple purposes, but the real purpose is to say, you know, if the government's going to collect information from me, I ought to have a right to know what they're going to do with it. I ought to have the right to know if I have to provide it. I ought to have the right to know who else is going to have access to it. And I should also have the right, if I don't like what I'm told about those things, to basically say, I won't give you the data. okay? I'm old enough that my kids were mostly pre this stuff. So what I've tracked on lately is my grandkids, okay? And the first time I ever saw the, I'm going to forget what it's called, the questionnaire they send you before the kid goes to school. And I won't mention what school district this was in, but if any of you remember those questionnaires, they are very detailed. And they contain very sensitive personal information, okay? Including things like, does the kid wet the bed, okay? And I understand why people feel like they need to ask those questions. On the other hand, I know that the Data Practices Act says when those kinds of information are collected, that parents have a right to know what's going to happen to the information and whether or not they have to provide it. So that's what this is about, okay? An additional reality of that particular part of the Data Practices Act, the legislature was looking for a way to make it meaningful because they knew that it was probably going to be hard to do that when you're asking people to say, for example, to a school, I ain't going to give you that data about my kid because people are worried that that might somehow affect the child. So what they did is they put in an additional qualifier which says that once the government tells you these things that are listed, they're essentially held to that as a promise, okay? They cannot use or disseminate data in a fashion other than what they tell you, okay? Thanks. So now, I'll skip some things. Okay, now, our Data Practices Act says that anybody can walk into a government entity and say to that government entity, and this is going to sound strange to you, do you have any data about me? And the government entity has to tell you if they do, okay? And they have to tell you that no matter how the data are classified. So if a government entity has confidential data about you, you have a right to know that they do. You can't get access to the confidential data, but you have a right to know that they have it. Okay? Now, once you know a government entity has access to data, has data about you, you have a right to get access to it, if it's private or public. And this part of the Data Practices Act says you can't get access to that data within 10 days of your request. Okay? I talked to a guy today who's been trying to get data out of the city about himself for 6 months. And the response he's getting from that city is he gets nothing. He doesn't even get an acknowledgement that he sent him a letter. So part of our discussions we have sometimes is how you sue a government entity. Now, once data is there, you can get access to it, to inspect it for nothing. You could also get copies of data about yourself or your children, and the government entity can only charge you the reasonable cost of providing the copies. They can't charge you anything for searching out and retrieving the data because they're supposed to be set up in such a way as you get access. Okay? Now, the last thing we'll talk about, the bottom of the page, going over to the next page. Actually, it's the second page or your right. And this is one that I'm always surprised that people don't use more often. Our statute gives people the right to challenge the accuracy and completeness of data that's maintained about them. Okay? One of the kind of, I hate to use terms like defining moments, but one of the things in my life that really, really affected deeply how I think about all of these things was a woman who contacted me 30 plus years ago. In her daughter's file in the school district in which she lived, which was not Stillwater, by the way, was the notation that her daughter was retarded. Okay? And she went to the school and she said, my daughter's not retarded. Okay? And they said, well, our observations, our professionals conclude that she is. Okay? This family took the kid to the University of Minnesota. They had her tested at a very costly process. They took that information back to the school and said, you know, the University of Minnesota experts say our daughter has a very obscure learning disability related to hearing. And so please change this information. We don't want the notation retarded to follow our daughter for the rest of her life. And the school refused to change it. Okay? And so for the next at least 5 years, she and the school district and its attorneys fought over that one word. Okay? To the extent of more money than I want to think about. Okay? And I think eventually she won. Now in the process, every once in a while she'd get mad. And so one time her attorney, who happened to be a guy I knew, got a call from the school district and said, Mrs. So-and-so was in here looking at her child's file, and when somebody's back was turned, she grabbed it all and ran out the door. And we're going to call the police and have her charged with stealing government property. So her attorney got a hold of her and found out where the garbage can in which she dumped it, and she took it back. Okay? And so I try not to spend too much time on that story, but to me it illustrates why sometimes it's very hard to understand why reasonable people can't be more reasonable. Okay? So now, last thing. I've mentioned the Department of Administration a couple, 3 times where I used to work. In one of the legislature's many attempts to make this easier on everybody, including citizens and the government, they gave the Department of Administration the authority to issue what are called advisory opinions. Okay? They're not binding, but they have some legal effect. And so the statute that deals with that essentially lays out what the commissioner can give opinions about, including data praxis issues and open meeting law issues. Tells you what that effect is. And the Commissioner of Administration has now issued something like 600 plus advisory opinions, maybe up to 700. And they're on the state database under the Department of Administration. They're searchable with keywords. So if you want to look to see whether or not somebody's ever had an issue like the one you're dealing with, you can look at that database. Okay? And like I say, they do have a legal effect. The primary legal effect from a citizen standpoint is if you have a commissioner's opinion that's favorable to your position and you have to sue about it, a judge is supposed to look with a certain amount of deference at that opinion. Doesn't mean because the commissioner said whatever that you're going to automatically win. But my experience when I was still working was judges look at the commissioner's opinions and they say, well, okay, you know, I could spend a whole lot of work doing this, but I'll just look at the commissioner's opinion, and if it makes sense to me, I'll follow it. Okay? My favorite was a judge who went to great lengths to say, I don't have to follow what a bureaucrat says. And then she adopted the opinion language almost word for word. So, whatever works. So, I'm going to stop talking and we'll take questions. Oh, and help me remember when you ask a question to repeat it so it gets picked up. I already forgot that once.
Thank you, Don. Before we go into the questions, which is the bulk of our program tonight, I just wanted the board members of the Minnesota Coalition on Government Information to stand and just give a brief affiliation, maybe starting with John, where you did your life's work.
I'm John Porter, retired, but for 40-some years I was a media attorney with Baker Daniels, representing the Star Tribune in extracting government information from government agencies, opening up meetings, among other things. But that was a good part of it.
Gary and
I'm Gary Hill. I'm chair of the organization. I spent 32 years at Channel 5, a lot of that running the investigative unit, and I served as the state freedom society of professional journalists. So I've always had a hand in this. That's where I got to know Don, call him up and say, how do I get this data? And so I just stayed engaged in these issues throughout, although I am also retired.
My name's Helen Burke. I'm a board member. I currently am employed by Hennepin County Library. Was the government documents librarian. I've moved on to more administrative, but it's great to make the information that Don is talking about, to try to make it available or to explain the process as I can to people who come forward. So thank you for being here.
Pat.
I'm Pat Doyle. Was a reporter for about 39 years for the Star Trib and other newspapers covering the legislature and a number of different issues, involving public access to government information.
Karen Schmeichel's already introduced herself. She's also a board member. Is there anybody in this? Okay. Let's go right into questions. And address them to Don or address them to one of the subject area people. Seth?
Yeah, you talk about defining data and information. One thing I'm interested in is meetings. How does meetings fit into those definitions?
The question is how do meetings fit into the definitions in the Data Practices Act? The technical answer is they don't, okay? There's a separate statute that deals with open meetings in Minnesota. And what it says essentially is governing bodies are subject to the open meeting law. There are certain things they have to do to conduct meetings, notices, etc. One of the places where there is an information intersection is we'll take a school board, is talking about something and all members of the school board have a piece of paper or something on their computer screen that's really the subject of what they're discussing. That piece of paper or whatever's on the screen, copies have to be available to the public in the meeting room. Okay? Does that get at what you're trying to? Yeah, okay, good.
More questions? Yes.
School districts mailing lists, if you request that and they give you 3 different tiers of if they want to charge one amount for nonprofit, they want to charge one amount for community, and then a higher amount for a business, how is that even legal? And even if you tell them, well, I'm not for profit, but I don't actually have a nonprofit form, but they still want to charge you the highest amount. I don't see how that's, when you're asking for their mailing list of students.
Okay, her question goes to what can be charged for mailing lists of students?
Yeah, so the households that go to a certain school.
Okay.
So you want the mailing addresses, their lists, and they will give it to you for a fee, but they have different fees for nonprofit, profit.
Yeah.
Is that legal?
The answer, as far as I'm concerned, is no, it's not. Okay, because the data practice, if they've been to the legislature and gotten some special authority to charge different fees, which I'm not aware of, then it would be legal. But if they haven't, the statute basically says when people get copies of public data, they can charge certain things, and I don't see how you can get charged differently because of your status. Now, the one thing to understand, when you say this about student addresses, okay, which we know down in Cottage Grove is a big issue, it's probably going to affect their school board election. There are 2 laws that regulate student information. One is a federal law, and then the Data Practices Act kind of dovetails into the federal law. The federal law is called the Family Educational Rights and Privacy Act. It was enacted in 1974. Like everything else in the world, the acronym is FERPA. Okay? FERPA says all student information is, for all intents and purposes, private. A school district can designate certain information as directory information, and if it does that, then under the Data Practices Act, that directory information becomes public. But to get there, they have to go through a process, number 1, of designating what information is directory information, number 2, informing parents of what they've designated, and number 3, giving parents the right to opt out of that, okay? And if in a given school district, I'm surprised in, what is this, 2017? Yeah, 2017, that any school district these days is selling lists of student addresses to a private company. That just surprises me, okay? It's also the kind of thing that in terms of how your district is run, you can go to your school board members and say, I think this is a bad idea and I think you should change the policy, because they don't have to designate anything as directory information. Where it gets tricky is when you've got things like athletes. Okay, I used to, when I used to do programs with school attorneys, they'd say, well, you don't want the world to not be able to find out who scored the touchdown in the winning game. Well, of course not, okay? But that's different than a student address. Okay?
One strategy you might use is just to ask the district under what statutory authority they're making that decision.
Good.
I guess the one other point is that the government entity, school board or whatever, does not have to charge. It's entitled to charge, so that it could set up categories of nonprofits or parents or whatever that it will not charge anything for. But setting up different tiers where it's charging different amounts seems to be out.
Yeah, I hope you heard that, because John's point is well taken. Charge or not charge, not charge different levels. That's just weird to me. So.
Yeah, I mean, this school district said they wouldn't turn over the list unless they received a check for so much, and it just, I mean, it was unbelievable.
Every once in a while I get downright diabolical. So you probably won't do this. So go in and ask to inspect and sit there and write down the addresses.
So if I ask, because that's what I generally do, is I ask to inspect. So I can inspect a mailing address and not have to pay.
If they've gone through the directory information process and determined that those addresses are public, then it's subject to free inspection. One of the issues,
yeah, you don't have to hand copy. That's why we have photos.
Yeah. Well, yeah, but one of the issues now, and her point is well taken, is people take their phones in. And we have government agencies complaining to the legislature that people like you are doing that and they shouldn't be able to, because that deprives them of the revenue.
Pat, did you want to jump in?
I was just going to ask about that point. Currently, though, people can do that. Bring in your camera, take pictures.
I don't know, Pat, because the statute doesn't deal with that. It really does depend who you're dealing with.
But I mean, is it a technological, a different way of copying down information rather than writing it?
Maybe a case of begging forgiveness rather than seeking permission. Gentleman in the third row, did you have a question?
Yeah, is there any provisions in the Data Practices Act for withholding information based on trade secrets?
Yeah, his question is, can a government entity withhold data because it's a trade secret? And the answer is yes. There's a section of the Data Practices Act that defines trade secret and says if it really is a trade secret, then it's not public. Okay? Then you get into weird discussions about whether or not something really is a trade secret. So.
Because we have previously, for a software project, had requests for proposals out, and the vendors then, provide their proposal, and then subsequently one of the vendors was not awarded the contract and requested all of the other proposals, and at that point the issue of trade secrets came up. And I was just, curious how the statute was written, but I can look it up, I imagine.
Yeah. His question is about RFPs and whether or not requests for the proposals that are received in response to RFPs, whether or not there can be trade secrets. Part of the problem, and this is another one of those modern life things, the proposals on the vendor computers are all printed on a page, or either electronically or paper, on the bottom of which or on the top of which this says this is a trade secret. Okay? So it could be the address of the company and it still gets printed out as this is a trade secret. And so where you end up is whether or not a response to an RFP is really a trade secret really does depend on whether or not it fits the definition of trade secret in the statute. And our trade secret definition is pretty tight, okay? It's really designed to be more like things like the formula for Coca-Cola. Not, we can do this work within, 6 months or whatever is in the proposal. So.